At first glance, the recording of this traffic stop might seem like just another procedural interaction, a standard pretextual stop, a few questions, and a padded sense of oversight through body-worn cameras. But listen closely, and the story becomes less about traffic law and more about the erosion of constitutional guardrails. The law is cited often in the footage, but just how lawfully is it being applied? The traffic stop originates with two officers, Jim Lewis and Samuel Terrell of the Alexandria Police Department, in pursuit of a red Mustang for an alleged violation of Louisiana revised statutes 32 on 124 and 32 on 352, referring, respectively, to improper turn signalling and a modified exhaust. From the outset, the initiative presents itself as one grounded in order, but when the dashcam and CCTV footage later confirm that the driver did, in fact, use his indicator, the stated legal basis of the stop folds in on itself. It's here that the first cracks emerge, not in the couple's compliance or cooperation, but in the foundation of the officer's claimed authority. The verbal pacing and syntax of Officer Lewis starts to raise flags within the first 90 seconds. His tone is calm, practiced, bureaucratically polished. He asks if the driver has a firearm in the vehicle. The driver calmly and promptly declares that he does, properly stored in the back seat. This candor from a citizen should cue a level of mutual respect. Instead, it transforms into the officer requesting the driver place his hands on the bumper, an action that precedes consentless searches in far too many bodycam cases. An important legal threshold appears here: reasonable suspicion and how it justifies certain types of detentions or interactions. But there's no sudden movement, no odour, no visible contraband, nothing that rises to the level the Fourth Amendment requires for a frisk. Yet the officer insinuates concern and proceeds to reset the power imbalance through control gestures rather than evidence or articulable suspicion. By the 3-minute mark, the driver politely denies a vehicle search. His tone remains cooperative, non-antagonistic. Under Terry v. Ohio, officers may conduct a brief pat-down for weapons if they have specific reasons to believe the person is armed and dangerous. Possessing a firearm, especially one disclosed immediately and legally housed, does not meet this standard by default in states that allow firearm ownership. Here, the constitutional line between officer safety and citizen rights begins to blur, and not by accident. Following this, the conversation pivots. Officer Lewis delivers a pseudo-Mirandized introduction, citing the Fifth Amendment and reminding the driver he may choose not to answer questions. But immediately after handing over this right, the officer continues to ask increasingly personal inquiries. It's a psychological tactic, one that builds compliance through a semantic loophole. Offer the right, then overwhelm it. With continued questioning, it becomes performative constitutionalism, offering rights verbally while eroding them in application. Now pay attention to the escalation mechanics. Though the driver asserts his right to privacy, denying consent to search, the officers persist in questioning and posturing physically as though he said yes. Their body language, tone modulation, and spatial control signal to the civilians that refusal, while technically allowed, isn't truly accepted. The officers present their ongoing questioning as if it's just routine conversation, masking the power dynamics at play. But in deeply structured policing, there are no casual conversations during a traffic stop. The moment a citizen answers a question while detained, the encounter changes. Because the person is not free to leave, their answers are potentially self-incriminating. And when the officer invokes Miranda yet continues interrogative behaviour, it builds a misleading environment where citizens can be tricked into compliance through de-escalated language couched in coercive positioning. At minute 6, there's an especially telling section. The passenger asks if she may record her fiancé for her own safety. She references a past incident where bodycam footage was allegedly lost. It's a powerful moment, not because it's emotional, but because it echoes a truth many Americans, especially in marginalized communities, now internalize. Video may be the last tool between personal safety and systemic denial. Her ask is modest, yet existential. Can I simply film? The officer denies the request, citing their own cameras, while insisting on her device's neutrality, even though they've made the driver physically vulnerable by patting him down without probable cause. The denial of her right to record, acknowledged under the First Amendment, shows the arbitrary boundaries officers all too often draw. The law doesn't bend, it's either enforced or eroded. Here it disintegrates under the officer's discretion, not any legal mandate. As the footage continues, the officer circumnavigates the balance between control and explanation. He admits there's no narcotics, no visible contraband, no warrants. Yet the detainment continues. Why? Because once power is in motion, systems often don't self-correct unless they're checked externally. This is the operational inertia of over-policing, a process that pushes forward not on evidence but on momentum, and increasingly, ego. The illusion of conversation persists as Officer Lewis deploys phrases like, "You seem like a constitutionalist," in an ironically admiring tone, but the irony here is deep. Declaring someone a constitutionalist while simultaneously denying them their rights to privacy, refusal of search and open recording is a contradiction more severe than sarcasm. It's signalling positional power while undermining the very laws the badge is meant to uphold. And note the absence of any tactical escalation. From the civilians, no raised voices, no sudden movements, no refusal to cooperate beyond the constitutional boundaries where they have every legal right to draw a line. Yet the officers prepare as if danger is imminent, even as facts prove otherwise. This is where body language intersects with institutional culture. An overcorrection born not out of facts, but out of a system trained to suspect rather than protect. By the 18-minute mark, there's fatigue, visible and procedural. Video confirms no outstanding problems. The driver has committed no crime. The firearm is legal. And yet the moment that cements the case, documented in the opening hook, reveals the culmination of systemic breakdown. The partner is told flatly that she is detained. Her access to her phone is denied again, even though it is not illegal for a passenger to make a phone call during a stop unless it poses a legitimate threat. Their rights shrink not through confrontation, but through compliance. And for the officers, the absence of contradiction becomes justification to press forward, not because they must, but because they can. Just over 20 minutes into the encounter, a citation is issued, finally, but its content is sparse, almost perfunctory. A blank slip with a court date, no detailed information, no final explanation reconciling the aggressive tone of the stop. Instead of closure, the citation feels more like cover, an artifact to paper over the constitutional violations sustained throughout the engagement. Part 1 ends here, but the story is far from finished. The lawsuit that eventually follows, over $35 million in damages, is not just a number. It's a signal flare in the larger conversation, when the badge becomes a script and the Constitution becomes optional. Accountability moves from the patrol car to the courtroom, and sometimes only then. In the next segment we move deeper, not just into what the Bodycam captured, but what it truly reveals when examined frame by frame, phrase by phrase, because beneath every word uttered in control lies a citizen taught to remain silent, not by law, but by force of habit. The second act of this footage unfolds not with adrenaline, but with pressure. Steady psychological pressure applied through positioning, language, and delayed resolution. At 21 minutes into the encounter, there is no new evidence discovered, no active threat, no developing probable cause. There is only the continued assertion of control. At this juncture, constitutional law demands constraint. Without articulable suspicion or evidence of criminal activity, the stop should be coming to a close. But in real time, the legal expiration point is ignored. Instead of ending, the detention drifts laterally into extended questioning, tactical positioning, and subtle intimidation. This is not a stop, it's a stalemate, prolonged by institutions that conflate authority with discretion. It's here, in the absence of physical escalation, that a more insidious kind of conflict sharpens. The kind you don't see in raised voices or drawn weapons, but in tone, authority framing, and procedural manipulation. The weapon isn't a taser or a baton, it's time. Officers stretch the stop in minutes, baiting responses while appearing casually conversational. Legally, this is critical. Prolonged detention in a traffic stop is unconstitutional under Rodriguez v. United States 2015, unless it's directly tied to the original reason for the stop. Once checks are done, license, registration, outstanding warrants, citizens must be let go. But what happens when officers use unprovable suspicions, or worse, gut instinct, to extend that moment? Around the 22-minute mark, the officer revisits a key question already asked and answered. Is there anything in the vehicle you shouldn't have? He had asked it earlier, and the answer, both verbally and with a clear lack of physical indication, was no. By repeating it, he's not seeking information. He's testing resolve. The repeated questioning is not fact-finding, it's leverage building. In this paradigm, citizens are treated as reservoirs of compliance, waiting to be tapped slowly over time. This becomes apparent when the officer revisits whether there's marijuana in the vehicle. He already knows the answer. His body language is relaxed. His partner is engaging more with posture than policy. But the implication undercuts the setup. It's not about drugs. It's about pressure. The likelihood of discovery is low, but the cost of prolonging refusal, of merely asserting your rights, keeps rising. And that's entirely the point. There is another detail that deserves full analytical weight. The officer's use of the phrase, "You seem like a constitutionalist." On paper it seems like harmless banter, perhaps even a compliment. But in context, it's a revealing linguistic strategy. It isn't a neutral observation, it's a subtle pejorative. It's the rhetorical equivalent of labelling someone a sovereign citizen, often used to discredit or marginalise someone invoking their rights. Why is this significant? Because when the legal invocation of constitutional rights, refusing a search, remaining silent, recording the stop, is reframed as reactionary or conspiratorial, the standard is reversed. A citizen exercising rights is cast as being difficult. And when that framing comes from an officer mid-investigation, it doesn't just reflect bias, it threatens the fairness and neutrality of the entire process. Here, constitutionalism is turned into deviance. This reframing becomes more evident when the passenger, Gracie, is thrust into the legal grey zone. Her role, seemingly minimal at first, becomes central. The moment she expresses a desire to use her phone to protect both her rights and her fiancé's, the reaction is swift. Her inclusion in the traffic stop's perimeter tightens. Despite being passive, non-threatening, and not the driver of the vehicle, she is told she is detained. She is told she is not free to walk away. And her phone, her only tool of self-documentation, is seized, not under warrant, not by protocol, but by verbal fiat. This is not enforcement. This is power. And more importantly, it's happening in full view of the Bodycam. A system meant to enforce transparency, now complicit through operational theatre. The presence of the camera, rather than restraining overreach, seems instead to embolden it through plausible deniability. After all, this isn't physical abuse. There are no slurs, no punches, no obvious transgressions. But the constitutional violations in this case are procedural, and that's precisely why they're harder to address and more dangerous to ignore. Because when abuse takes the form of bureaucratic performance, when an officer calmly recites the Fifth Amendment, denies a phone call, blocks a recording, and re-questions already answered inquiries, it does not look like traditional misconduct. But it is. This is how civil rights erode without alarms. The passenger is not suspected of any crime. She possesses no contraband, makes no false statements, and poses no threat. But because her presence is used to elevate the pretext, there's a gun in the car and she's near it. She is now an involved party. This classification shift has enormous implications. It turns the ordinary context of a traffic passenger into a suspect-adjacent figure, subject to detention without cause, and denied First Amendment liberties under the guise of safety. This segment of the Bodycam footage demonstrates exactly how qualified immunity, unchecked, enables misuse. And here lies the institutional critique buried in the scene's calm. When officers are trained to see ambiguity as threat, when civilian questions are reframed as offences, and when rights are interpreted as obstacles, then misconduct becomes not exceptional, but operational.
Another document appears near the 27-minute mark of the footage. The citation. Thin, almost mockingly minimal. It is offered to paper the stop without honoring its original claim. A handwritten court date. No outlined charges that explain the verbal authority deployed moments earlier. The failure to signal claim false per external video is quietly hidden within this gesture of closure. But it isn't closure. It's camouflage. The purpose of this document is not to proceed with lawful punishment. It's to justify the last half hour of detention. A placeholder for legitimacy. This may seem minor to viewers. A blank ticket? Who cares? But in jurisprudence, this has weight. Because if the predicate for the stop was fabricated, as video evidence seems to show, then every subsequent act is derivative of that illegality. The pat-down, the questioning, the detainment of the passenger, all constitutionally compromised. A false premise in law enforcement is not just poor discretion. It's a chain reaction that can
invalidate entire cases. This is where bodycam footage becomes more than reactive content for outrage or public curiosity. It becomes primary source evidence in capturing not just what happened, but what patterns exist. Because this wasn't improvisation. The script, the repeated questions, the referencing of amendments, the use of phrases like legally detained, and the subtle discouragement of phone use suggests something more chilling. Practice. This wasn't learned on instinct. It was taught. It was observed. It was distilled from departmental culture. And therein lies the problem. When misconduct takes the shape of departmental habit, the blame cannot stop with the individual officers. Civil lawsuits may name them. Settlements may punish them. But unless the policies, the training manuals, the field supervision, the culture of pretextual stops itself, are addressed systematically, then the pattern continues unbroken. New names, same methods. As Part 2 closes, so does the handoff, from officers in control to citizens in crisis. The stop ends. The threat is over. Or so it appears. But what's left behind are not just bad memories. They are legal violations, sealed into bodycam timestamps. Grain for grain, this video outro is not a footnote. It's discovery evidence. And while the officers return to patrol as though the day is over, for Mario and Gracie, the consequences are just beginning. Stress injuries, financial burdens, legal questions, PTSD, and perhaps most damaging of all, the realization that the justice system, sworn to protect, has instead trained itself to pursue. In Part 3, we'll unpack the civil lawsuit, its federal implications, and exactly how this local traffic stop frames a national pattern. Because while the footage is specific, the tactics are not. And the next stop might be different in city, but identical in form. As the final moments of the bodycam footage begin to fade, officers walking away, the stop technically concluded. What lingers off screen is not resolution, but residue. The camera may stop recording, but the constitutional damage left behind does not switch off so easily. For Mario and Gracie, the encounter did not end when their vehicle was finally released. It initiated a deeper conflict between citizen and government, now to be settled far beyond the curb where it began. This case transitions from local detainment to federal litigation through a tool designed for precisely these moments. 42 U.S. Code, paragraph 1983. This vital civil rights statute enables individuals to sue state officials who violate constitutional rights under colour of law. It is the mechanism by which citizens attempt to pull constitutional theory back into lived reality, particularly when every right they invoked on the side of the road was steamrolled under practice as policy enforcement. The lawsuit filed by Mario and Gracie is a $35 million civil action against officers Jim Lewis and Samuel Terrell, directly, implicating the Alexandria Police Department in broader allegations of misconduct. This number may seem extraordinary, but to understand it, context is key, not just of the violation, but of the structure in which this misconduct was allowed to occur. At the heart of the legal complaint are 5 distinct claims: unlawful seizure in violation of the Fourth Amendment, deprivation of First Amendment rights, to record public officials, violation of due process, under the 14th Amendment emotional distress under Louisiana. Civil Code Article 2315 negligence and failure in supervisory responsibility. Each reflects a level of injury sustained, not just physical or emotional, but civic. What's being contested here is not a single misspoken word or an ambiguous pat-down. It's the erosion of meaningful distinction between suspicion, policy, and power. A dissolution of the line between protector and violator. Let's revisit that power structure. In the initial moments of the stop, the officers cite obscure traffic codes to establish a legal pretext. But pretext only works if it rides on validity. Article 32(124) concerning signal usage was contradicted by external video. Article 32.352 targeting a modified exhaust was never substantiated in the footage. These statutes appear not as tools of safety enforcement, but as scripts for justifying roadside intrusion. That shift, from legitimate observation to weaponized bureaucracy, is at the heart of Mario and Gracie's legal claim. When the officers deployed their authority based on known falsehoods, they invalidated every downstream action under the fruit of the poisonous tree doctrine, a legal principle that deems evidence and processes stemming from illegal actions equally invalid. The ramifications are systemic. The actions captured in this footage aren't operating in a vacuum. Similar patterns have emerged across the nation. Bodycam footage revealing soft-spoken but constitutionally aggressive officers citing misapplied laws and extending stops under false pretense. In too many cases, qualified immunity, originally designed to protect good faith errors, becomes a legal shield for repeatable harm. The doctrine of qualified immunity often bars victims from seeing their cases heard. Officers argue that unless clearly established precedent forbade their behaviour, they cannot be held liable, even if their actions are blatantly unconstitutional. It is a doctrine drawn not from statute, but from judicial expansion, and one that continues to protect power instead of precedent. But here, the facts documented are stark enough to pierce that defence. The passenger was explicitly denied the right to record, after stating a reason based on prior officer misconduct. The driver was subjected to a warrantless pat-down without particularised suspicion. The stated reason for the stop, failure to signal, is demonstrably false based on video evidence. The passenger was told she was detained with butinsaikshimki, no articulable justification beyond proximity to a legally owned firearm. If these measures are deemed permissible, it sets a dangerous precedent. That mere presence during a legal stop allows state actors to detain, question, and restrict otherwise innocent individuals. And perhaps most critically, the bodycam shows none of this occurring in crisis. There is no visible threat, no rise in voice, no evasive movement. The calmness of everyone involved clarifies one thing: this wasn't a one-off mistake under pressure. It was operational rhythm. It was protocol masquerading as discretion. This is where the lawsuit goes beyond personal justice. It becomes structural indictment. The officers do not invent these tactics in isolation. They're scripting. You're being legally detained. No phones during a traffic stop. You can pass on questions under the Fifth Amendment. Suggests practiced recital, not improvisation. These are lines learned, tested and repeated. And if that's true, the liability does not rest solely on the shoulders of the men in uniform. It belongs to the command structure that trained them and the policies that incentivize such behavior. Consider this. What happens when traffic enforcement shifts from safety to gateway? Stops become pretexts, not engagements. Civilians become suspects by default. Constitutional protections transform into inconveniences, disposable if they interfere with the process of control. This is not simply broken policing, it is degraded citizenship. In Gracie's most consequential moment, she is told flatly she is now part of the stop. The trigger, her request, to use a phone. Not defiance, not aggression, just a request. One built, explicitly, on the fear of lost footage from a prior incident. That she is correct to be cautious only sharpens the irony. When she is told no phone calls on traffic stops, the legal ground collapses. Courts have affirmed the right to record public officials in public spaces repeatedly in the last 2 decades. That includes filming stops, especially for non-involved parties or passengers. Law enforcement arguing that internal cameras nullify this need misunderstands the right. It is not about redundancy, it is about accountability from a different angle. Independent documentation allows external verification that recordings weren't stopped, not edited, not misfiled. When the state controls the only record, power updates the file. This sequence challenges the idea that rights expressed are rights respected. Mario and Gracie both invoked their Fifth Amendment rights. Liberty did not follow. They cited their unwillingness to consent to searches. Intrusion still followed. They attempted to record. Devices were withheld. The pattern is not coincidental. It is illustrative. Signals were given, not of illegality, but of constitutional awareness. And those signals became grounds for suspicion, for extension, for escalation. The lesson embedded for many viewers here is troubling. Knowing your rights may not protect you. It may provoke longer, more invasive outcomes. What does that reveal? It reveals an adversarial model of public interaction, wherein law enforcement, instead of welcoming legality, suspects it. Instead of respecting refusals of consent, pushes past them. Instead of viewing the camera as standardized observation, sees it as threat. This is institutional rot. Not violent, not visible at first, but deeply embedded. And unless exposed through financial consequence, sworn testimony, community reform, and loss of immunity, it persists. Which brings us back to the federal lawsuit. Not just the dollar figure, but the demands within it. Compensatory damages are sought for emotional trauma, public humiliation, anxiety, and civil rights injury. Punitive damages aim to deter further misconduct within the department. Policy reform is advocated through pressure mechanisms tied to leadership and Attorney General oversight. And tucked within, an ask that goes beyond litigation. That the training doctrine that allows these stops to escalate be deconstructed. Not reformed cosmetically, but replaced operationally. This includes changes to disciplinary procedures, review of pretextual traffic engagements, firm enforcement of limits under Rodriguez, and departmental consequences for misstatements of law on camera. Because if officers are allowed to repeatedly declare this is a legal detainment without basis, and courts do not punish misrepresentation as misconduct, we have functionally replaced the Constitution with officer discretion. And a democracy governed by discretionary force, applied unequally, is not democratic at all. The footage may appear calm. The voices never rise. But within that quiet lies a larger story, of authority unmoored from humility, of institutions unwilling to correct themselves, of scripts repeated so often they've replaced logic with rhythm. Mario and Gracie's story will not solve nationwide abuse, but it adds to a growing ledger, city by city, plaintiff by plaintiff, building a case not just against individual actors, but against a culture that has learned how to perform legality without living by it. And the cameras, external and internal, catch it all. They don't just film abuse, they film absence. Absence of empathy, of restraint, of accountability, and lawfulness. That absence is the real subject of this documentary. Not the stop, not the citation,